Yeah. Hello. Good morning. Welcome, Mr. Sultan Mahmood, and good morning.
Good morning, sir. How are you, sir?
Fine.
Sir, what about your mother? Is she fine now?
Yeah, she is improving.
It's very cold. I think in Delhi. Uh, you have to be need to take care much.
You are not audible to me properly. I think there is some vibration in your voice. Am I audible to all of you?
Hello, sir. Am I audible
Yeah,
now?
hello.
Sir, am I audible?
Yeah, now you are audible.
Okay. Sir, I'm saying your mother has to be take care much because this is very cold in
Yeah,
Delhi.
that I understand. That I understand, and I appreciate your concern.
Yes, sir.
Yeah,
Thank you.
welcome, Ms. Anupa.
Thank you, sir.
Good morning.
Good morning, sir.
Good morning, Ms. Prakriti Malla, and I welcome you. Well, today I propose to deliberate some country specific responses to refugee reception and how across the board treatment of refugees have been there. There are some specific countries which are important because it has become a fashion on the part of refugees to inch towards them. Whenever this is something which we have been collectively witnessing, and I hope you would also be agreeing with me, ever since the refugee migration, particularly in global south nation states have started, global north nation states have been the preferred destination of refugee lot. And they were always have been in search of greener pastures in these lands. United States of America and many European nation states, including countries, continental countries like Australia, New Zealand, And in the vicinity of Australia, many nations have been the important destinations for refugee migration. It is altogether a different story that majority of the nation states who have been hosting refugees influxes and refugees exoduses comes from global south nation states. In my very first submissions, when we have conducted orientation classes of international refugee law, in the very first class I have submitted that 85% of the refugee population, global refugee population, is presently and currently being hosted by global south nation states. Among these committee of nations, Australia is one of the most important country in hosting refugees, denying refugee reception, admitting refugees, swapping refugees, because it is incongruous that in a country as large, wealthy and multicultural as Australia, treatment of asylum seekers and refugees is a national preoccupation. This kind of interaction or conversation is not about rights or responsibilities, my dear friends. Rather about stopping the boats and smashing the people smugglers' business model that is generally seen in case of Australia. It raises a very, very important question. How did we reach a point where both major political parties have become engaged in a race to bottom about how best to shut down Australia as a place of refuge for people who take to the sea? As in many countries, asylum seekers are an easy target for anxieties about national security, unemployment, and demographical imbalances or demographical composition. Asylum seekers cannot vote, so their voices are marginalized in political discourses, debates, and deliberations. Refugees are increasingly moved outside the Australian community, and Australia has also established immigration detention centers as well. And Australians have been dividing refugees between, within inverted commas, them and us. Again, in inverted commas. Politicians of Australia have fueled fears, my dear friends, that asylum seekers present a threat not only to the integrity of Australia and its borders, but to the national fabric as a whole. And certain elements of the media have not only fanned the flames, but poured on the accelerant. If you take into account the entirety, what kind of a scope of Australia's program in the admission and resettlement of refugees, that is also a major concern. After Australia, we would also be discussing what has been the role so far, the humanitarian assistance, interventions, as well as other important facets of help that have been extended by the countries like United States of America to refugees, and how they have been received in United States of America, as well as in, or rather in entire North America, and that includes Canada as well. Australia's refugee and humanitarian program, my dear friends, consisting of two important sub-programs. There are two important divisions of this particular program. On onshore program, there is a first program is known as the onshore protection program. And there is another important program that also runs parallel to the first one, and that is known as the offshore resettlement program. Onshore protection program is available to people seeking asylum. I mean, the very first program is available to those people who are seeking asylum after their arrival on the shores of Australia. But there is a condition, and that is a violation of the fundamental principles of international refugee law, because that condition demands that there has to be an availability on the part of refugees, and they have to produce a valid visa, a valid document consisting of visa. For example, if a student is visiting, then he must have some kind of a visa. Or in case of a tourist, again the visa requirement is there. People in this particular category are able to apply for a permanent protection visa, which allows holders to live and work in Australia as a permanent resident. Since September 2013, if I am not wrong, offshore protection program has excluded people who arrived in Australia by boat or without any kind of a valid visa. Offshore protection program, resettlement program, contains three categories: refugees, special humanitarian, and community support program. The refugee category, my dear friends, applies to people living in other nation states who have been identified as refugees by UNHCR and referred to Australia for resettlement. The special humanitarian category applies to people who are subject to substantial discrimination in their home country. And they are proposed, they are persuaded for the visa by a person or organization in Australia. And this entire process also includes immediate family members of the people who have been granted protection in Australia if they are available because of their previous arrival. Community support program has been started by the government of Australia in 2017. This particular program, that is the community support program, or CSP we may call it, under these programs, or this particular program enables refugees to be resettled with support from individual communities, groups, or business houses in Australia. But at the same time, there is an annual limit of 1,000 community support program, which are included in the total of Australia's refugee intake. At the same time, the Australian government introduced Operation Sovereign Borders Program. That program, the government of Australia has started in the year 2013 as a military lead border security. This military lead border security operation aimed at combating maritime people smuggling and protecting Australia's border. But my dear friend, it is extremely unfortunate that government of Australia is not sincere enough in hosting refugees. It is altogether a different story that as an island nation, Australia has long suffered disproportionate concerns along being invaded from the sea. This apprehension has always been there in the political minds of the governance structures in Australia. From the 19th century or mid of the 19th century, there was a fear of yellow hordes invading from the north, an idea that came to underpin the country's, Australia's racially repugnant white Australia policy. This should be understood as a final vestiges of which were not what you call dismantled until 1973. Examples are replete because there has been an unwritten policy on the part of the government of Australia. It has never been notified, and there cannot be any kind of advertisement or propagation of this kind of a policy. But this policy has always been there, and that is an unwritten policy. Legal institutional framework or responsive framework, which have been designed under the Constitution of Australia and under international human rights law framework, and that includes other important independent specializations or branches of human rights, including international maritime law, international refugee law, international humanitarian law, and international criminal law, and the fundamental principles which have also been agreed upon as well as subscribed under the broadly the customary international law stands violated. But this policy is still continuing, and that is a policy of racism. Or in other words, we can put it like this: all white Australia policy. So this policy is being, because many boat people have been turned away by the government or the border security officials, or those who have been manning the onshore what we call borders or maritime borders of Australia. In 2018 as well as in 19, in the vicinity of Australia, there are other small island nations. Notably, one of the most important island nation state is known as PNG, Papua New Guinea. The Supreme Court of PNG has recently declared the establishment and erection of certain enclosed detention centers at the instance or under an agreement between the government of PNG and government of Australia. The Supreme Court of PNG has already declared them as illegal occupation and ordered their dismantlement. Some of the detention centers have already ravaged to the ground, because of the directions of the Supreme Court of PNJ. Because there was an agreement and there was some kind of a political understanding between the two nations, Australia and PNJ, that the Black Sea people from Rwanda, from Somalia, Ethiopia, Nigeria, and other nation states, including Congo, Liberia, and these are known as the boat people, who alighted at the shores of Australia, they have been turned away and sent back to PNG and housed and detained in these enclosure centers. So this has been some kind of a unwritten administrative responses to the refugee influxes in Australia. In the post-war period, the Australian government actively brought ships of displaced persons from Europe. It is a different story. They brought refugees, and particularly the displaced or forcibly displaced people in European nation states, because of development, because of some kind of internal displacement, because of some civil war, due to some kind of a civil strife in some specific geopolitical entities in Europe. These people have been given some kind of a margin of migration and they have been welcomed in Australia, but it was again propelled by an idea of white supremacy. When these people from European nation states were persuaded to settle in Australia, so it was not the humanitarian approach of the government of Australia. It was not an international commitment or state obligations of human rights on the part of the government of Australia. These kinds of welcome of migrants or displaced people was exclusively propelled by a policy which was exclusively based on Australia's declining population and workforce. It was not at all induced or driven by humanitarian impulses. No, that was not the story. So in such a situation, you can very well understand, though today we have been talking that nihilistic and narcissistic popular nationalism or right-wing nationalism has started and engulfing major geopolitical entities in the global north as well as global south. But recent conclusion of national elections in United States of America has also proved that there cannot be a situation where the white supremacist movement are going to be permanent fixations. Rather, this policy has already been dismantled. Inauguration of the new presidency headed by Joe Biden is an indication that how this particular policy could not serve its desired purposes. Media reports as well as in other whether it is print media, electronic media, and other important news houses, they have been carrying, if you take into account the last decades or the last 2 decades of racism in Australia, you will find that many Asians, including the South Asians, have been attacked. And they included the permanent residents from Asian nation states in Australia, student community, business houses, and ordinary citizens, or including tourists, have been attacked because of racist forces. If you take into account with recent United Nations High Commissioner for Refugees and other reports, all reports are unanimous and indicated the highest number of displaced persons worldwide. We cannot forget the conflicts in Yugoslavia and in Rwanda, which ultimately contributed in the current estimates of the forced displaced people, who are generally known as and addressed cumulatively as refugees, and they constitute 79.5 billion refugees worldwide. I would not go, and I should not go due to the paucity of time. I have collected it entire data of last 20 years. What has been the pattern and trends of migrations worldwide? But what is important is, and that is, particularly in case of refugee protection, that refugee problem has always provided a suitable moment for debate about the legal context of displacement. As a student of law, as a student of international law, as a student of international refugee law, it should be the concerns of all stakeholders, including the student community, including myself. Protection from displacement, my dear friend, is one of the key contemporary challenges that is being confronted by international law. As modern history has often shown, displacement is particularly closely linked to armed conflict, and it may take either an internal form or involve the crossing of international border, or we may call it an external, what we call, dimension. The ongoing conflict in Syria, as well as response of the military junta towards the state of Rakhine in Myanmar, and how it has paved the way for the most persecuted refugee community in the history of human displacement, that comes from our backyard, and they are the Rohingya people, Rohingya refugees. It has established some kind of a tragic correlation. Those who have studied the history of Europe, and particularly the First World War as well as the Second World War, how United States of America along with Great Britain, they have bombarded direct, it was a direct what you call bombardment of German cities. And how Austria, Poland, and other nation states in the vicinity of Germany were bombarded by Hitler. If you equate those pictures with that of the modern what you call pictures of the cities in Syria, we do not find any kind of a difference. I am not able to distinguish between the death and destruction that we have inherited after First World War and Second World War, or in Syrian civil war. These pictures in German archives, British archives, and United States Library of Congress are safe, and we can visit those places. And the electronic media who has aired and shown these pictures of the Syrian civil war, we do not find any kind of a difference between the depiction of death and destruction, how the civil societies have been devastated during First World War and the Second World War and the Syrian civil war. There is no difference at all. If you compare the Korean War, death and destruction, with that of the Vietnamese war, there is no difference. In the recent memory, if we compare what kind of ravages, rubbles, devastation, destruction of humanity we have witnessed during the Gulf War, we do not find any kind of a difference what we have witnessed in Second World War. So there is no difference between pains and sufferings. There is no difference between the outcomes. There is no difference. We are not able to distinguish in the aftermaths and consequences and inheritance of war. And it is also axiomatic from the preamble to the United Nations Charter that it has been the consistent policy immediately after the inauguration on 24th of October of the United Nations Charter on 24th of October in 1945, and original member states one by one stated in that very San Francisco conference that we are unanimously and resolutely going to save the succeeding generations from the scourge of war. But what happened to their commitment? What has been the threshold of their conviction? Again, the war and the conflicts have become the part of the national interest. And that is why the human displacement has become the biggest what we call concern of the international community. It does not mean the political leadership and the world statesmen and other important international civil society individuals hailing from different backgrounds, from different specializations, from different businesses and different specializations. They understand each and everything. They understand the consequences, outcomes, repercussions and ramifications of their actions, but even then they go for war, because sometimes even the war is also in their national interest. War has also provided the business opportunities. In the name of reconstruction, rebuilding societies, nation states, institutions, that requires a lot of upfront investment. But only one question nobody is able to answer. And the question is what to do with the refugees. Because as a student of international refugee law, I generally ponder over, and the question that agitates my mind is, what is the consequence of such kind of a military engagement? What is the result of these kinds of hostilities? And the result is the production and generation of refugees. Because there is one particular notion, and that notion should not be forgotten. Whenever international law adopts any convention, and this convention, the basic and the most fundamental purpose of each and every convention, international convention, whether the conventions were adopted under the auspices of the League of Nations or the organization that succeeded the League of Nations, that is the current United Nations organization, a multilateral arrangement to oversee the world affairs, we find one common word, and that is known as peace. When Universal Declaration of Human Rights, even prior to that, the establishment of the United Nations organization through UN Charter, and it is also evident it is one of the most important cardinal principles upon which this multilateral organization came into existence. It was primarily the idea of peace after two what we call wars. They wanted to establish peace. Universal Declaration of Human Rights has also come, and that was adopted for the purposes of accomplishing peace, global peace. Whether it was the first covenant on civil and political rights, it was a common feature. It is a pervading line of argument that each and every, whether we are talking of international 9 core human rights treaties, these core international conventions or the core international treaties, which numbered in totality 9, the fundamental purpose behind each and every adoption, each and every conclusion under the auspices of the United Nations organization has been one particular aspect, and that is the establishment of global peace. Nobody can deny it. If we are talking of human rights, we are talking of human dignity. And what is human dignity? And how to define human dignity with a single word? It is peace. Under international law, under international criminal law, my dear friends, again it is the concerns of individuals who are fleeing persecution. Because a person who is evaluating his conditions, his circumstances and surroundings, he is of the view that he is fleeing persecution. But it may not be the same case in the eyes of the law enforcement agencies of the country of origin. They may brand it persecution. Because of the political opinion, because of some kind of political actions of an individual A, so in such a scenario, under international criminal law, fair trial means peace. If I take you to another important area of international law, just to crystallize my line of argument further, how refugees have always been in search of peace. Any kind of a migration, remigration, transmigration, repatriation, resettlement, reintegration, human mobility, or any kind of a relocation, it is always in search of peace. And there have been refugees who have become and adopted a new kind of a project which is known as the peace activism. They want to integrate their voices in the decisions of the nation states who are presiding over their destiny, that their voices may also be integrated in their decisions. And it comes from the peace activism on the part of refugees. So what I was talking, that there are, as a student of international law, this is my humble submission to all of you, including myself. I always keep myself in a state of reminders that we should be sensitive enough to understand the basic and the most fundamental import of international law. The basic idea and basic philosophy of international law gyrates around peace, and it is peace directly. Suppose I wanted to give you an example of international environmental law. Under international environmental law, or under the rubrics of the climate change law, what is peace? It is the preservation, my dear friends, it is the preservation of biodiversity. That should be understood as peace, an element of peace. Under comparative constitutional law of SAARC nations or international constitutional law, the democracy of judicial remedies must be known as peace. And this is what the refugees have been seeking in all the geopolitical entities after their arrival in the host communities. We have to take a very comprehensive interpretation of the idea of peace, and that canvas of interpretation must incorporate and encapsulate one of the most important section of the human existence, and that is known as the refugee population. So the refugee population has been denied their lawful, legitimate, and relevant place in the human schematization. The refugees are being demonized, dehumanized, and deprived from the very basic fundamental requirements. I'm not talking of the entire range of rights, but the minimum continuum of humanitarian assistance is being denied to them. And that poses a very, very pernicious, detrimental, and horrendous situation. Because nobody wants to be a refugee. And the biggest casualty in any kind of a human migration happens to be one of the most important rights. Nobody recognizes that particular right, and that is a right to belong. It is the very basic and the most fundamental right. I would also be sharing almost 20 rights or 18 rights which I have identified, but you will not find their mention, expression, or any kind of a commitment on the part of the community of nation states or international community. No convention, no arrangement, whatever the arrangement so far, including the latest one, the global compacts on refugees and migration, do not share any kind of a commitment for those very rights. Because the human mind cannot reduce into black and white, abstract rights, philosophical rights, the rights which are epistemological, teleological, which are psychic in nature, which can only be felt, which do not have any kind of a solid, what we call, understanding. Rather, they are abstract in notion. So we have to understand even those rights. I would definitely come out with those very rights when we are going to discuss the entire range of refugee rights as per the South Asian constitutions as well as as per the international humanitarian law, human rights law, international criminal law, or other notions of rights are concerns. And it is also further axiomatic that there are many classes of refugees. There are refugees, there are asylum seekers, there are stateless persons, there are migrants, economic migrants, immigrants, irregular migrants, regular migrants, legal migrants, illegal migrants. These are the and at the same time there are internally displaced persons. But my dear friends, it is a game of naming migration. It is a game of blame shifting. It is a national what you call project of blame shifting in each and every geopolitical entity you will come to know. Name shifting or the attribution projects, I generally call them in the world of international refugee law. Attributing refugees with these kinds of nomenclatures is basically denying them their due, demonizing their existence, dehumanizing their persons, and treating them as a subhuman. It is nothing but narcissism, fascism, Nazism in different what we call manifestations. So that is why we should avoid and we should not be the part of this kind of a projects like naming them, because naming has always been a game in the arsenal of the national governments. Because whether somebody is fleeing persecution, whether somebody happens to be or treated as a refugee, somebody is treated as a migrant, or somebody has become an internally displaced person, or somebody has become stateless, what is important? The result remains the same, and the result should be the basis of any kind of a humanitarian intervention and humanitarian assistance. But that is not at all done by the national governments. They are still indulging, and they have made certain important promises in the global compacts on refugees and migration. I would also be coming to that. Let the time come after 3 or 4 weeks, we would also be taking up those particular aspects. The present scenario, and that is the part of the larger refugee milieu. Irrespective of the nature of human displacement, what is important is, my dear friends, it is the protection needs, which are generally not met by the states, which often find themselves, and challenges, and particularly sufficient levels of protection are the basic requirement. But those sufficient protection levels are not at all provided by the government. That has created a lot of problems for the national, governments. In the light of this entire deliberation which I have presented before you, creation of a uniform international instrument comprehensively dealing with international human displacement must be initiated, despite the fact we are having 1951 UN Convention relating to the status of refugees, with its additional protocol of 1967, 2 important global compacts, entire what we call a powerful pool of instruments in the area of international human rights law framework, and other important specializations which are also directed to preserve the human dignity during armed conflict, during peacetime, and before the law enforcement agencies, including the judicial tribunals. But still I feel that the element of complementarity is important. If a solution or the solution of the refugee problem is not possible under 1951 convention relating to the status of refugees, then there are other important human rights oriented frameworks, legal frameworks. And those frameworks, on the basis of complementarity, must also be invoked and have been invoked on many occasions. But still, we lack, despite the fact that New York Declaration has been translated into action. And more than 180 countries have already become the privy to these two important global compacts on refugees and migration. But even then, I feel, this is my personal understanding, you have every right to disagree with me. In the presence of so many instruments, we still lack a very, very comprehensive understanding of entire, refugee problem. Because this is my individual capacity, I am sharing this, line of argument with all of you. I appreciate on a very critical footing the adoption of the New York Declaration, the 2016 on refugees and migrants. But I do not personally feel comfortable with this declaration and its nomenclature. I appreciate the political acknowledgement of the international community of the refugee problem and the recommendations, particularly not all recommendations, not all scenario that has been envisioned how to solve refugee problem. Some of the visions I have also talked of when I have submitted my PhD thesis in 2002 on refugee law. And one of the most important arguments that I have submitted in my PhD thesis, my dear friends, that the refugee burden sharing should be replaced by responsibility sharing principle, and that has been reflected in the New York Declaration of 2016. I talked of the international solidarity, and I wanted that the political solutions must be found of refugee problem, though it is humanitarian and social problem, but at the same time it cannot be solved without political intervention, and we require a political will. And some other recommendations were also there in my thesis. But I was not talking of as a separate instrument. And today, I still believe that the New York Declaration of 2016 on refugees and migrants and the subsequent global compacts on refugees and migration, two compacts which were adopted by the international community in 2018 in the month of December, but I think on 19th of December in 2018. These compacts, including the New York Declaration, should have been adopted as an additional protocol, as a second additional protocol to 1951 Convention. That would have been more appropriate. Because as a part of 1951 UN Convention relating to the status of refugees, legally binding element would have been stronger. These global compacts, in my understanding as a student of international refugee law, are full of political will. acknowledgement is good, but how to ensure a legally oriented execution, implementation, and enforcement of these global compacts? That does not, and that has not been ensured by the political will of the international community. So we were supposed to have, instead of having the New York Declaration, we could have a New York Additional Protocol in 2016. And whatever we have adopted in 2018 could have been adopted in 2016 itself as a part of that New York Protocol. So this is my understanding, and you are not at all, suppose, though I am writing on these, aspects. And some of the guidance I have again studied my own thesis on these, lines, what I have stated in 2002 as a student of international refugee law. In these, circumstances, we have forgotten another important, population who also, find itself in the refugee-like situation. And this refugee-like situation is equally, horrendous and heart-wrenching. And that is the situation of the internally displaced persons. No major country can claim that it is without internally displaced persons population or internally displaced population. We are having around 8 million internally displaced persons in China. We are having almost 6 million internally displaced persons in Philippines. More than 6 million. We are also having, if I am not wrong, I will have to check, around 3 million internally displaced persons in India. We can count Indonesia, United States of America, Colombia, Syria, Iraq, Democratic Republic of Congo, Sudan, South Sudan, Pakistan, Nigeria, Liberia, Somalia, and we cannot forget even Venezuela. That is the latest addition. Mexico, Brazil, and even the global pandemics like COVID-19 has also pandered to intra-country migration, including the global migration. This trend of internally displaced people has been, increasing year by year. After every year, we are getting a new what you call additions of population of internally displaced people or persons. Because there are many other important, nation states like Burundi, Sierra Leone, Uganda, former Yugoslavia. These are the, very few, prominent states to mention in case of internal displacement. Because the internal displacement is a recurring trend of internal displacement in many countries, particularly in Africa or Afro-Asian nation states. And notable among them have been the countries like, Democratic Republic of Congo. In such a situation, we should not forget the Syrian crisis. That has also been highlighted in many of the reports on the forced displacement people. And Syria has also presented a major new factor in the global displacement. Because if you take into account the entire forced displaced population at global level, that there are only 4 to 6 nation states who have been responsible, and they have been branded as the major contributors in the global displacement of people. From South Asia, it is Afghanistan, my dear friends, who is the refugee generating country, as well as on a very small and tiny scale, it is also hosting refugees from Central Asia. But it constitutes the major what you call country that is producing refugees. Though in South Asia, India comes as a refugee hosting country. Pakistan is also generating refugees as well as the hosting refugees. Bangladesh is another refugee hosting country in South Asia, and that has, on a very unprecedented scale, it has been hosting Rohingya refugees, despite the fact it is not a party to 1951 convention relating to the status of refugees with its additional protocol. But because of its commitment with that of what you call, whether it is a commitment, but as a student of international refugee law, this is my well-considered opinion that the Bangladesh has really established its human rights credentials under Article 33 subclause 1 of 1951 Convention relating to the status of refugees, that it has been preserving, protecting the idea of non-refoulement, despite the fact it is not privy to that particular principle or any of the provisions of 1950, but it has been upholding Article 31, Article 32 and 33 of the Constitution of Bangladesh. So it has been hosting refugees under the constitutional law as well as under customary international law. So in such a situation, what has been the response of the national governments of these 4 to 6 nation states who have been generating, producing and contributing refugee population? Other countries are Syria, Iraq and Sudan. Including, we should not forget how the political opinions have also displaced many families in the just concluded elections in Uganda. And I don't know what is going to happen in Burundi in the face of what you call of general elections. At the same time, if you take into account the last 20 years of the refugee displacement or the forced people displacement, then we should not forget Kosovo or Bosnia-Herzegovina. Because the largest in a single country in 1999, my dear friends, in a single year, Kosovo happens to be a region where the largest number of people had fled. Though right now we are having, since 2017, we have been witnessing the migration and the flight of Rohingya refugees from Myanmar into Bangladesh. But in case of Kosovo, almost more than 9 lakh people have fled in a single year. And that was the year 1999. And therefore, When we are talking of internally displaced people and persons, it has been at the highest level in the last 20 years. And this population of internally displaced persons was produced in Syria, and that is almost more than 4 million people. More than around 5 million people happens to be internally displaced. In case of Syria, it's a very, very worrying trend. It's a very obnoxious trend, my dear friends, because people, because of the political reasons, people are being forced into displacement, internal displacement in countries like Syria. I will also share in my PPT presentations as well the specific what we call numbers as well, and how these numbers have keep on increasing, and cumulatively speaking, if you assess the latest report that has been released last year, that is 2020, not only by the United Nations High Commissioner for Refugees, but the other important international agencies who are working in the area of international migration, refugee protection, and they have documented and collected this data and presented very beautiful, incisive and intensive analysis how the migratory movements are going on, who are the refugee hosting countries, and what exactly are the problems, and who are the non-state actors who are involved in the human migration. Because world miseries, human displacement kind of situations have also given rise to a mushrooming of criminal syndicates as well, who are indulging in human trafficking. In the Aegean and Mediterranean sea routes, it is the non-state actors who are indulging in human trafficking, and they are minting money out of this kind of a misery. And sea transportation along the Mediterranean Sea has also presented another important challenge. As I have submitted that the government of Australia demands under its two programs that the valid visa should be there. It is a violation of international refugee law norms. Why it is a violation? What is the purpose of international refugee law? That is the most important question, and that should be what we call handled. We should not forget that the refugee problem cannot be tackled, it should not be handled with the application of immigration legislations of various geopolitical entities. What is important is international immigration law does not handle any kind of a migration. When international immigration law or immigration legislations of different nation states are not in a position to address the problems of refugees, then in such a situation, international refugee law instruments comes into picture. Or in other words, let me put it like this, When international immigration law stops, then international refugee law begins. That is the difference between the two. So it is a violation of Article 31, Article 28, and Article 33 of 1951 Convention relating to the status of refugees. Because travel documents, valid papers, visa, and other important, papers relating to the identity credentials of a particular individual cannot be asked for. Immigration officials, border, checks officials, law enforcement agencies posted at the, borders of the nation states are not allowed under international refugee law to demand these kinds of, papers from the people who are fleeing persecution. That is the mandate. Or who are, fleeing conflict and war. Such kind of a documentation is not possible. Because when people flee persecution or war or conflict, then in those, situations, it cannot be expected from them, and they do not have any kind of a, premeditated, plan of fleeing. It's a sudden migration. It's an abrupt, what you call, relocation program. It is not the collection of, documentations like, passports, identity documents, and some other important, papers in the wake of any kind of a, conflict. It has never been the first priority of the people who are confronted with these kind of situations. The immediate requirement for these, peoples is always how to save their, what you call, life. And when people immediately try to save their life, they abandon rest of the things. They immediately go for sanctuaries and safeties. It is their, what you call, understanding, and it's a human understanding. So therefore, when immigration stops, immigration law stops, refugee law begins. And this is a point of distinction, and that should not be, forgotten. And that is why the national, what you call, governments and the national or other, the geopolitical entities, different, jurisdictions, they have, separate legislations for immigration and refugees. And this is the point of, distinction. And this is how we should try to understand the idea of, refugee law. Because it is axiomatic from Afghanistan, how people have been, fleeing persecution or the, war, conflict, or internal civil strife, or the armed conflict of a non-international character which is going on, that has also produced refugees who took shelter in their neighborhood, that is Iran, Pakistan, India, and other, nation states. And people from the urban centers in Afghanistan, they also took refuge in many European nation states, including Germany. Because continued, fighting between Taliban forces and other political, factions in Afghanistan has displaced almost what we call more than 2 million Afghans. And that is a population within, Afghanistan. Many villagers have been, forced out of their homes and herded into, Kabul and the vicinity of, Kabul. My friends from Afghanistan would appreciate, and you are also, requested to correct me in my submissions. For many years, Iran and Pakistan have hosted the largest refugee population in the world for many years. Now it is Bangladesh, now it is Turkey. Iran provides asylum to over 2 million Afghans. And these Afghans have been living in urban centers in the state of Iran. Even in Pakistan, that is also, hosting around, 2 million what you call Afghan refugees who are currently living in camps. And one of our, just passed out student, Mr. Mujibur Rahman, was also a person from Afghanistan and presently living in Pakistan. So you can very well understand. And from the Afghanistan quota, he has completed and passed out, successfully completed his LLM from the South Asian University. He also shared the chilling facts of, migration. What kind of a problems these, guys have, faced when they migrated from Afghanistan? Because in the very outset of my, submissions, what I have, submitted is that nobody wants to be a refugee. And this is a famous what you call, quote, which I generally resort to. Sir Sadruddin Aga Khan made this particular, statement. A Japanese lady, Sadoko Ogata, when she was the High Commissioner, United Nations High Commissioner for Refugees, she also, carried the import of this particular, understanding. Even in 1992, if I'm not wrong, Boutros Ghali, who has been the, Secretary General of the United Nations Organization, has also, written a book. And the title of the book, if I'm not wrong, please correct me, and that is Peace Agenda for the 21st Century, something like that. That was the, title, but it was a contribution in the area of peace. Long ago, I have, completed this particular, book of Boutros Ghali. He also, in case when he was, deliberating on this particular, issue of what you call of, refugee protection, he has also, even the current Secretary General of the United Nations Organization was also immediately before assuming the charge of the Secretary Generalship of the United Nations Organizations, he was the UNHCR, the High Commissioner for Refugees. So he is also having this particular, understanding. And this is my, well-considered opinion. If we find a single refugee, or there is a persons of refugeehood on this beautiful planet, then definitely we are not living in a world that is wedded with peace and tranquility, as envisioned in the preamble to the Charter of the United Nations Organization. And therefore, it should be the understanding of all the nation states. They must subscribe to the idea of peace, because in the persons of so many human rights and refugee law instruments, we are still lacking one of the most important point. And the point is in a form of a question. And this is my question to all of you, including myself. And that, this question keeps my mind agitating. Is there any kind of a possibility to explore and to fix the responsibility of refugee producing countries? Will there be a possibility to compensate refugee hosting countries? Should a reparation and compensation be demanded from the refugee producing countries by the refugee hosting countries? Because nothing moves in this world without money. When we are talking of humanitarian intervention, humanitarian assistance, and when we are deliberating the responsibility sharing principle, So these are some of the important notions which requires the financial implications. And there has been a trend, let me further crystallize my line of argument with the domestic law and order problem, and particularly from India. It may be of some use to ponder over. When one particular provincial government in India has came out with an ordinance, with a law, that the people who are damaging, though there are penal provisions already in existence, but those provisions have also been further made very strict, and the provisions against those people who have been found to have indulged in looting and arson and damaging state property or national property, then the compensation would be extracted out of their property. Many people have been fined in India. Even they have been fined with a very gigantic and colossal amount of money. China has already implementing this kind of a law in their domestic jurisdiction. So shouldn't we have this kind of a law against those countries who have been indulging in producing or generating a refugee exodus? And the cost of these exoduses of people, if I am allowed to use this biblical notion, these nation states, those who are hosting these exodus of people, shouldn't be they compensated? We must ponder over, because this should also be taken as the fourth or fifth or sixth durable solutions. We would also be deliberating this in detail when I am going to take up the idea of durable solution in the days ahead. So in such a situation, internal displacement as well as the refugee exodus and refugee influx has been there. From the recent developments, we can also take into account another important geopolitical entity, and that is Sudan. Sudan is generally acknowledged to have one of the largest internally displaced populations in the world. Around some more than 4 million, between 4 to 5 million, according to many estimates which have been recently released by international agencies, including UNHCR, IDMC, another important international organization. In Sudan, these internally displaced persons were produced mainly from the war-torn south of Sudan. I mean, not South Sudan, but south of Sudan, when before its division into two nation states, Sudan and South Sudan. Around 2 million internally displaced persons were produced. And ultimately, this particular population, the war produced population, has moved and entered into Khartoum and other parts of what we call of Sudan as a nation state. Many have been removed from the city and placed in special camps by the governments in Sudan. Uganda, in its vicinity, another important country of just now, the general elections have been held, and the incumbent president has again won, Museveni, who inherited and succeeded Idi Amin. And it was the he has already been in office for the last what we call more than 35 years, and again he won the election. A young leader, Mr. Vidi, got defeated. So Uganda has pursued a notably liberal asylum policy, which have been, witnessed by the international refugee defenders, particularly in the recent years in this particular, country, and now has a refugee population of around what we call, 3 lakhs. And this refugee population predominantly comes from the southern part of, Sudan. At the close of what we call of 20th century, armed attacks by Ugandan rebels had almost what we call displaced more than 40,000 of refugees and disrupted some other important ongoing projects pursued by the United Nations High Commissioner for Refugees settlement programs. It has been witnessed because right now in more than 100 countries, my dear friends, United Nations High Commissioner for Refugees, financed programs are in operation. But many of the national governments have not been assisting. Many of the nation states are not coordinating in a manner in which it is expected from them to coordinate. That level, that threshold of coordination is missing. I can give you an example of Palestine. Palestinian diaspora has spread to practically every corner of the globe. We find Palestinian. Even in Aligarh Muslim University, as a student in my graduation days, I was having more than a dozen classmates from Palestine, from Iraq, or from Iran. And there is no unanimity among these 3 groups, even in the class. Because of their nationalities, they were not comfortable in the classroom. Iraqis and Iranians were always, fighting even for a place, for a particular seat in the class. And sometimes the Palestinians were also indulgent. So this Palestinian diaspora is practically available in each and every corner of the world. But at the same time, the largest number of this diaspora, over what you call more than 3 million, are still found in Jordan, in the neighboring what you call nation states like Jordan, Syria, Lebanon, West Bank, Gaza Strip. So this is the region, or the in the Quranic what you call mentions in the land of Canaan. Palestinian is one of the oldest refugee problem in the world. This should not be forgotten. Even a special agency was also constituted by the United Nations organizations to deal with the problem of Palestinians, Palestinian refugees. As has been the case in 1923, if you recall, in the third class of, or the third stage of my submissions, I have also mentioned when we were talking about the history of the refugee movements, then for the first time a special high commissioner under the Charter of the League of Nations was appointed, especially for the Russian refugees. So even the Palestinian refugees also got a separate program of the United Nations, United Nations organization in addressing their problems relating to migration, relating to what we call refugee camps, their reception, their rights have been what we call separately dealt with, but it has not produced the desired results. The most important point, and that is a point of concern, And that really agitates our mind, because when we are dealing with refugees and the persons, and I find those students who opted for international refugee law, because there are some important branches of law which can only be studied by very or extremely sensitive people, and 2 papers or 3 papers are important for that. Very sensitive students generally go for those very papers, and I'm not creating any kind of a division, please. It is exclusively on the basis of sensibilities. It does not mean rest of the students are not sensible. It is basically a question of priorities. But, or in other words, let me put it like this: among all the subjects under the sun, there are some sensitive subjects like international humanitarian law, international human rights law, international refugee law, international criminal law. I find these papers very, very sensitive, because we require the highest model of sensitivity for any kind of an academic, juridical, judicial, justicial engagement. Because the question of peace, question of justice, question of democracy, question of sensibility, sensitization are involved. And therefore, it becomes very, very important to understand these ideas of humanity and its existence. Because this is an issue of human existentialism. Why I am pointing it out? I am pointing it out only because that ever since the Palestinian refugee problem came into existence, it has not been resolved. Even a single dimension of the Palestinian refugee problem has not got any kind of a ray of hope with regard to settlement, resettlement, repatriation, reintegration, or any kind of a complementarity oriented solution. And it is also axiomatic from the fact, my dear friends, that the 4th generation of Palestinian refugees is now growing up in the refugee camps. And these refugee camps initially, my dear friends, and very unfortunately and ironically speaking, these camps have been constructed by their grandparents, by their great grandparents. When I am saying the 4th generation is growing up or the 5th generation is growing up. So you can very well understand what is the pain of becoming a refugee or being a refugee, what kind of a pain these people, feel when we are talking of. Even the first generation migrants or the first generation of refugees are not able to feel comfortable in the host communities. They are basically paying the price. And how we perceive who happens to be the natural inhabitants of the host communities, do we have this kind of a understanding? And how do we perceive? So Palestinian refugee problem has got a historical, what we call, reference. Though the Syrians have also been there for one single decade, their migration has started in the month of March in 2011, when I introduced this subject in South Asian University, that is international refugee law. So in this particular backdrop, we should not forget the pains of the Palestinian refugees. But so far, international relations of today are concerned. So far, the political transformation of the global post at this stage is concerned. So far, other important, international priorities are concerned. The nation states at international level have forgotten, practically speaking, Palestinian refugees. Palestinian refugees are no more there. They do not have any kind of a conspicuous persons in the priorities of the international community. Various US administration and the peace processes which have been initiated by various, predecessors of the Joe Biden has not been, successful or have not been successful in dealing with this kind of, problem. It has got some kind of a religious implications and political ramifications. Because the refugee problem, particularly of the Palestinian refugees, they do not, pose any kind of a, benefit. Benefits cannot be accrued. There could only be one benefit: how to get a Nobel laureate for peace if this problem is, resolved. And Nobel laureate for peace is not the priority of the political leadership, except what we call, Yasser Arafat and Shimon Peres, when they have been, conferred with this, Nobel laureate. Otherwise, the Palestinian refugees are no more, figured in the international priority list of, disputes. If it is, listed over there, then it remains on paper. No concretization, no concrete or discrete, steps have been taken, because it is the, political will of the state of, Israel and United States of America. They are the biggest, what we call, stakeholders. And they are not, very keen to have, because see the policy of occupation, construction of, Israeli wall that, separates and creation, it creates a new kind of, development, and that has recently visited by the International Court of Justice as well. When we were, talking of customary international law, if you recall, I have shared this particular, example when we were, talking of the customary international law and its evolution, and what exactly are the, fundamental principles which have been concretized in the area of international human rights law. That is another important group of refugees that has equally suffered because of the role of the international, powerful actors, and that is the Bosnia-Herzegovina. In this particular, region, almost half of the, Bosnians, 5 million citizens were, uprooted during this particular, war that was fought from, 1990 onwards, particularly from 1991 and 92 onwards up to 2000. Up to 1995, and for the first time when Bill Clinton happens to be the president of the United States of America, and that in Dayton, a place in United States of America, in Dayton, an agreement was brokered by the Bill Clinton administration in resolving this particular, problem of, Bosnian refugees. It has also, displaced many of the, Bosnians were, made internally displaced, persons, and particularly the Muslims, which they have been, prevented from returning to their homes by the continuing hostility of other, communities and efforts of the political leaders to establish ethnically homogeneous territories. Many refugees, I mean the Bosnian refugees and displaced, people, are now making their way back to their homes, some voluntarily and others because their countries of asylum have insisted that they must allow themselves to be repatriated, as we have been, witnessing how the Rohingya refugees are being repatriated by the government of Bangladesh, and few individual Rohingya refugees have also been repatriated by the government of India. But the repatriation, how the norms of repatriation have been adhered to by the national governments, that poses a very, very important challenge to the international law on refugees or international refugee law per se. So that has generated another important, debate. And we must, national governments must try to locate the customary international law character of, repatriation that has not been done. That is another important dimension of, research that has not been researched, so far. Because that demands the voluntariness, and there is no voluntariness in the voluntary repatriation, because the repatriation has already been, and there is a unanimity of scholarship that whenever there has to be any kind of a repatriation of refugees to their country of origin, then voluntariness of beyond any kind of a reasonable doubt. Who is going to establish it? It is the person who is likely to be repatriated. Whether he is voluntarily willing to allow herself or himself to be repatriated by the government to his country of origin. Because he has already fled persecution. Whether the circumstances have become congenial and conducive for his return in his country of origin or her country of origin, that has to be established beyond any reasonable doubt. And there has to be an objective criteria for its determination. But we do not find the preservation and subscription of all these norms of and this is only possible under customary international law, because I feel repatriation, voluntary repatriation, has a customary international law character. This is my well considered opinion, and that is why I advocate, if there has to be any kind of a repatriation, under all circumstances it must be carried after establishing the voluntariness. There should not be any kind of a coercion, duress, or any kind of a temptation, or any greasing of palm of the person who is likely to be repatriated as a refugee from the host country to his country of origin or her country of origin. It is the fundamental responsibility of, and in such cases, the engagement and particularly the services of the United Nations appointed what we call groups, or the United Nations High Commissioner for Refugees, assistance must also be taken into consideration, because reintegration seems certain to be a long and very difficult process. Integration in the host country or in the third country. Given a country's continuing political tensions and economic problems, because the Rohingya refugees have created a lot of tensions. Because of Bosnian refugees, many neighboring countries were also grappling with political tensions, economic liabilities, because any movement demands some kind of a economic implication. And how to satisfy those demands of economic implications? It has been seen in many refugee migration, my dear friends, that in majority of situations the people fled from the urban centers. In case of any kind of a armed conflict of a non-international character in many geopolitical entities, this has been the pattern and trend that the people fled from the urban centers instead of from rural areas. We find very few people who fled from the rural areas. They have become internally displaced persons. And the people from the urban centers, particularly in the Gulf War, what happened? That from in Iraq, from urban centers of Iraq, people fled and took refuge in the neighboring countries like Jordan, Syria, and other nation states. And the poor people or people who are hailing from the rural background, the rural areas of Iraq, they have become internally displaced persons. This generally happens in each and every kind of a situation where armed conflict ensues. So Both people from Bosnia-Herzegovina were not an exception. And still there is a distrust, despite the fact that almost more than 25 years, a quarter of century has already passed to the war in Bosnia-Herzegovina. Even then, the people are not comfortable, and particularly lot of tensions, community, internal community or intra-community tensions are still prevailing. Then we are also having other regions as well, like Liberia, Sierra Leone, then Iraq, then Turkey, Angola, many other nation states, including in our backyard, Myanmar, then the Sri Lanka, then we are also having Burundi, Colombo, from Latin American countries, including United States of America. We are also witnessing in United States of America many what you call citizens from other nation states have been what you call there, and they have not been given any kind of a nationality identity card, or they have not been even recognized as refugees, particularly during the Trump administration. They have faced, embraced all kinds of discriminations. So these are some of the important what we call segments which should also be taken into considerations. And after Bosnia, we should not forget Kosovo and the Serbia, Azerbaijan, and recently what we call conflict that has also produced many refugees. The conflict between what we call Armenia and Azerbaijan, and active role of Turkey has also been there, and that has also produced many human casualties that should not be forgotten. And we would also be particularly the displacement because of the long standing armed conflict over Nagorno-Karabakh, what we call region, that has always a bone of contention between the two nation states. Particularly this is the region that is the Nagorno-Karabakh, a largely Armenian populated enclave within the Azerbaijan, that has always been a bone of contention. But at the same time, I'm not going into the details of its implications and international law character of this kind of a geopolitical entity. But my concern is relating to the human displacement because of this armed conflict. Then we should not forget Somalia, Rwanda, and other important, even the Eritrea, a very small what you call tiny nation states. Many people have been more than around 5 lakhs people from this particular tiny nation state, a long nation, I mean landlocked nation states, have been exiled and exiled in other what you call nation states. Then I will take up on the next what you call turn the response from South Asia, as well as we would also be deliberating another important what you call dimension. What is the concept of migration? How this particular concept got reception in the entire schematization of international law. That is going to be my brief. On the next turn, I will make a presentation on this one as well, and thereafter we will switch over to other important engagements. And today I have also received the complete list of all the students who have opted for international refugee law. Meanwhile, I have also collected a lot of material to be shared with all of you, and today in the night or by tomorrow I will also share the entire requisite material. But I would never be intending, and this is not my intention, to bombard or to what we call flood your inbox, and nothing should be counted, because I will also point out what is important from your examination point of view and what is not uh, relevant from the examination point of view. But since we are in the business of higher education, each and everything becomes very important, because you are going to play, all of us including myself are supposed to play different what we call roles in our academic life, as a legal advisor, as an expert opinion, as a part of some kind of a project funded by international agencies as well as the national governments in our respective jurisdictions. So the literature which I am going to share with all of you may be relevant for different what we call purposes. So you should not feel that I am flooding or making a bombardment of literature upon your juridical proclivities. So that has never been my intention. So with these, few submissions, I take your leave to leave, and inshallah, very positively on the next run, we are going to engage again. So I wish you all the best. Tomorrow, I think there is a holiday. Am I correct? Please, I need your guidance, Ms. Anupa. Will you be able to tell me? I think tomorrow we are not going to have any class due to the 26th of January. That is the Republic Day for India. Am I correct? Hello, anybody? Okay, let me check, and thereafter, if you do not receive any kind of a link for the class, so you should, assume that there is holiday. So let me check the, South Asian universities calendar specifically, that is also available on online. So thank you very much for the day. Wish you all the best.
Thank you, sir.
Thank you.